There are times when we all face situations that are not purely black or white. The definitiveness of an either-or situation would indeed make the comprehension, rationalisation and adjudication a much easier and simplistic process. We know, however, there is an area that falls somewhere in between. The grey. An area where definitives and absolutes do not match the mentality of a one-size-fits-all process within our justice system. One such landscape, deeply blanketed by this grey, is the intersection of self-defence and domestic violence in our society. Statistically, the prevalence of this in Australia alone is simply shameful, disturbing and unacceptable. On average, one woman will be murdered every week by a partner or former partner in Australia. In a cruel twist of fate, 2020 delivered circumstances that bred a COVID-impacted world, causing even more isolation for victims. Many were locked down in dangerous situations with perpetrators, resulting in 2020 earning the title of the worst year for domestic violence in Australian history. Legally then, where does black and white lay when it comes to those who fight back against their perpetrators? And how does this black and white hold up in court when it comes to a violent act that occurs out of fear for one's own safety? There is far more than black and white and countless shades of grey as we attempt to shine some light into the concept of how far is too far and when is enough on this, the next episode of Just Lawful.
Adelaide is the perfect place to set a horror story. You know why all those films and books are always set in sleepy conservative towns? Because sleepy conservative towns are where those things happen. Exorcism, omens, shining, poltergeists. Adelaide is Amityville or Salem, and things here go bump in the night.
Welcome again to Just Lawful, where things do indeed go bump in the night. My name is Daniel Panozzo and I am once again joined by my co-host, Sean Fuster.
Thank you, Daniel. Welcome, listeners.
Before we begin, a huge thank you to everyone listening. If you haven't heard our previous episodes, we would strongly recommend and greatly appreciate you going over to iTunes and Spotify, subscribing, leaving us a 5-star rating. That's how you help us get our work out to the masses and get our voices heard by those who really need it. A quick word about the following episode. If you do find anything we discuss distressing, please make use of the following support resources. The Domestic Violence Crisis Service on 1300 782 200. Domestic Violence Gateway Service on 1800 800 098. The National Sexual Assault, Domestic and Family Violence Counselling Service on 1800-RESPECT. For our interstate and international listeners, please make use of the resources in your local areas. I'm giving that warning again because before we begin this next part of our series, we want to make very clear our stance on this subject matter. We're approaching this topic from a zero-tolerance perspective towards violence. What we want to do, however, we want to examine the occurrences of when a violent act is done in the defence of one's own safety and the fear for their own life. It's safe to say that we both feel it's naive to believe that this topic can be approached with a simple black and white mentality.
And in no way, shape or form are we professing to be the experts on this. We're hoping to bring you the benefit of my exposure, my experience to cases where self-defense and domestic violence have intersected. But we also realize we are two white men talking about an issue that affects so many different people, predominantly women and children, all around the country, all around the city, all around the world. So our voices should not be the be-all and end-all on your thinking on this topic. And I want you all out there to consider going and listening to the people who know what it's about from an absolute first-hand perspective. I'm talking organisations like embolden.org.au, of course, White Ribbon Australia, another great organisation, au.reachout.com, one of the best Facebook pages on the subject you're going to find, which is called Destroy the Joint. Check out Destroy the Joint. And the work of journalists like my colleague here in Adelaide, Lauren Novak, and also Georgie Dent, who does incredible work in this space. It's not for us to tell you this is the shape of this problem. It's for us to tell you these are Sean's experiences with this issue and hopefully encourage you to go seek out and learn more.
Absolutely. We want you'd understand that we recognise there is a problem. What we want to hope to do in our next couple of episodes around this is we're going to bring to you some examples of what happens when it goes too far or when something occurs and someone does fight back. There's been a number of instances, and we want to look at that from a legal perspective. And of course, the way that we put our lens is a just versus a lawful situation. So we're going to examine some instances and occurrences which are probably going to make you think and feel and get a different perspective of how this occurs through our society and therefore flows into our justice system. Is that fair to say, Sean?
Very fair to say, because these are the cases that shaped my viewpoints on this. I came into covering courts in 2002, and the cases that we're going to cover span quite literally from 2003 until earlier this year in 2021. Almost the entirety of my journalistic career, these cases have spanned, and it's altered and shaped my thinking. I like to think for the better.
Yeah.
And one of the things that I want to examine as we go through this is how it's affected and shaped the law. We keep talking about the fact that justice and the law are not necessarily the same concepts.
Yeah.
I always believe that the law is mankind's best attempt at approaching the concept of justice. The way the laws have changed about domestic violence and self-defense are quite shocking, quite confronting, and quite infuriating, making them ample fodder for what we do on this show.
Yeah. And it's one of those things where we understand, for the most part, when you talk about law and laws being enacted, they are generally drawn up to cover a best case scenario of a catch-all of a majority of a situation. There's no particular singular law that can be written to cover every occurrence or circumstance or particular version of an act that occurs. So,
and further to that, there is legal precedent that says the more narrow focused you make a law, the more specific you try to target someone, the less just it is.
Yeah. So it's a very, I mean, by its own definition, it's a very difficult premise to get around in that sense. And when you start adding that element of humans in there and the way that we behave and our typical behaviours and thought processes, etc., it makes it a very, very difficult beast to try and get some rein in, I guess.
And this is very much a conversation that has spanned out of our coverage of the death of Zara Abrahimzadeh, the murder of Zara Abrahimzadeh at the hands of her husband. Yeah. This wasn't a series that we originally intended to do, but the more that we delved into that case, the more we talked about it and said, look, we have to talk about the other side of this as well, because one of the things that absolutely infuriates me beyond belief in conversations in this space are people who say, well, she should have just left. And we touched on that in the Zara case. Oh, she should have just left. Well, she couldn't leave financially, etc., etc. In her case, Zara did leave. She made the courageous decision. Not that anybody that doesn't leave isn't courageous. It just takes a lot of courage to actually throw yourself into the void that way, without the financial support, possibly without a house, without a car, without a bank account, without family support. Even that didn't save Zara because of the breakdown of the systems that we've now forensically examined and we'll talk more about with Zara's children in the coming weeks. I wanted to now explore what happens when someone can't leave and has to take that action, as you've outlined, Daniel, to save their own lives. What does the justice system make of those women?
Yeah, and that's where this next, piece of this series that we're creating around this is going to focus on. You touched on a very good point. That idea and the ideal of just leave, that is and that's where we talk about that black and white mentality. It's a very black and white answer. It's not as simple as, because if that was the answer, then we'd know how to apply that to every case.
If that was the answer, we wouldn't have anywhere near as many deaths. We wouldn't have one woman dying a week if it was as simple as just leave. But
No.
where do you go if you just leave?
Well, and that's the thing. As you said, not everyone can leave, and there are reasons around that. And the Abrahimzadeh case was a really good one that highlighted that. You're not just talking about the concept of leaving. It is that isolation piece away from family, friends, support networks. It's a financial perspective. It's an emotional perspective. It's an abusive perspective. So there are so many constraints around that where just leave is a very... And I don't want to offend anyone, but it's a very naive perspective to take on this.
Oh, look, I'll offend people. It is completely naive and unhelpful and unwarranted. And if everybody out there that's listening could delete it from their vocabulary right now, I would personally appreciate it.
Yeah. So to go on this, embark upon this journey, if you like, around this, there's a few ways we're going to look at this. the first one we want to discuss is, as you said, we're going to use the focus point or the lens of your experience through this. And as you said, it's around about 18 years there, about 2003 to 2021. 18 years of actually covering these cases, seeing this play out in our court system, understanding, I guess, where those attitudes first started from back in at 2003, how that has, I guess, molded and been amended over that time. And as you said, there's some relatively shocking, I guess, perspectives or outcomes that have occurred along the way to where we get to today. So how exactly, what experiences or how exactly do we want to do this, Sean?
Well, look, let's start with this. As I was pulling together the research for these next couple of episodes, I was going back through the advertiser's database. It's great to have that resource at my fingertips. When you pull up the name of a particular case or a particular victim, you don't just get those cases. You don't just get those articles. You also get all the ephemera surrounding it.
Mm-hmm.
One of the first things I noticed was that it was pulling up letters to the editor and, on-the-spot questions for people, face-to-face conversations with people,
Sure.
little things like that. Seeing over that 18-year period how the very early letters to the editor were things like, it's absolutely reprehensible that someone who kills another, regardless of the circumstances, is shown any leniency.
Okay.
And then you get to the more modern perspective where it's the law needs to recognize that there are situations that it is not equipped for, or where something like that might be justified, or where empathy is needed. On the whole, looking at those public reactions to the cases I've covered over the 18 years, there seems to be a trend toward greater understanding,
Mm-hmm.
greater empathy. But as we'll see, that doesn't necessarily soak into the bedrock of our legal system. Just because of that, I mean, we've seen it in everything we've covered so far. Just because the community thinks one way doesn't mean the courts necessarily do.
Yeah, and you're talking about a big spectrum, as you said. There's a huge spectrum of, as you've just outlaid, where that first, I guess, public opinion or attitude sat, as opposed to where it has now gone to, where we need to take into consideration what was the situation, circumstance, and maybe we need to understand that occurrence and what was happening for that person to get to that point, rather than just going, yes, no, was it a crime, was it a violent act? It's interesting, as you say, though, it hasn't necessarily soaked in, and as you said, from a justice system, it's perhaps a very different circumstance. As you stated, Sean, we're going to go back to, and start at the beginning. 2003 is where this all begins. And I want to ask, 2003, how far into your, I guess, journalistic career of covering courts were you at that point?
The start of 2003 would have been the first anniversary of my starting up as a court reporter. So February 2002 is when I technically started as a court reporter. So by March of that year, I'd been 13 months into the game.
So you're just a journalistic pup at this stage.
Very much so. I mean, I had been working in journalism since the age of 17, but
Sure.
in terms of focusing purely on court reporting, which had always been the goal, 13 months in.
Right. So you're 13 months in when you come across the first of the cases we're going to start to pull apart here.
That's right. And this is a very, very foundational case. This is the matter of Gwenda Elaine Savchik.
Right.
Miss Savchik was at the time a 47-year-old woman who lived in Renmark, which is in the Riverland, sort of on the border between South Australia and Victoria. It's the big fruit-growing area.
2-3 hours outside of Adelaide, north.
Absolutely, absolutely.
Lovely area, though.
It is, unless you were Gwenda Savchik.
Okay.
Because for Gwenda Savchik, life was not good at the time. She had been married for 19 years to her husband, Mark. They had a multi-million-dollar fruit-picking business.
Sure.
Lots of money involved. But, it started off well. It started off like all relationships do. But by 2003, things had well and truly soured. I mean, she had been physically and verbally abused by Mark almost the entire marriage.
Yeah.
Humiliation, strangulation. When
right.
people started noticing the bruises on Miss Savchik, Mark changed to hair pulling.
So it was visibly was actually leaving marks, so it was noticeable to those around.
That's right. And it was all motivated by jealousy.
Okay.
He believed that she was spending too much time on their children. Should have been focused more on him.
Wow.
That very egotistical, very me-first driven mentality. And Miss Savchik had never fought back.
Right.
You imagine that? 19 years of violence, humiliation, not just in private, but in front of people.
Yeah, right.
They would go to events, these multi-million-dollar fruit picking events, and he would just demean her in front of the clients, in front of other fruit pickers, tell her she was stupid, that she didn't know the business, that he didn't know why he kept her around. Absolutely, I think what they call it negging.
Yeah.
Just completely negative behaviour.
Humiliation.
Absolutely. Then in 2003, as we said, March, he's killed
Okay.
by a 1-metre samurai sword,
Wow.
stabbed through.
Okay.
Miss Savchik's arrested. She has no clear recollection of the moments leading up to the stabbing.
Mm-hmm.
And so, of course, she's charged with murder. As time goes on, though, this starts to get very, very thorny. And by July of 2004, her trial begins
Okay.
in South Australia. The prosecutor is a lawyer by the name of Liesl Chapman, now a district court judge. Prosecutor Liesl Chapman has a very different perspective on the case than what you'd think from what I've just laid out.
Okay.
She tells the jury that this was a deliberate stabbing,
Mm-hmm.
a murder, and that there was no altercation between the parties at the time,
Mm-hmm.
that Mark Savchik was sitting in a chair on a mobile phone, and Miss Savchik came up from behind and plunged the sword through him.
Wow. Okay.
That's her case. She says, the prosecution recognises that Mark Savchik was critical of others around him, in particular his wife, and recognises he could be verbally abusive toward her. The prosecution does not suggest there was never any physical assault, and recognises Mark Savchik spent most of his time drinking, with little time for his wife. That sort of behaviour may well have provided a reason for what happened that night, but it certainly does not provide Gwenda Savchik with a defence to murder.
Okay. So the prosecution there, just to get my head around it, has said that they recognise it was a deliberate act. However, there was no altercation at the time, and they're not saying that there wasn't. Certainly, there was verbal abuse going on. They're not saying there wasn't necessarily physical abuse, but at that moment there wasn't, and this was a deliberate act.
So they're splitting the infinitive here.
Okay.
They're saying, okay, this may well have been an abusive relationship. We're
Sure.
not saying it definitely was,
Mm-hmm.
but nor are we saying it wasn't.
Yeah.
We're saying at the moment
Yeah.
of the samurai sword stabbing, there was no danger to Miss Savchik.
Okay.
She had no reason to take forceful and ultimately fatal action.
Sure.
Their compelling alternate theory was that Miss Savchik was fed up with her husband's behaviour, and they pointed to a letter that she had written.
Mm.
And the letter says, I think you had better get your act together. You have gone out all our married life and got pissed. You're worse than a hooker whose legs are open. I thought things might change. I wanted to have fun. I must have been boring. I'm sorry for being boring. So you can see the case they're painting there. This is a woman who is fed up with an unhappy marriage that may or may not have been violent, and she's run him through with the sword while he was drinking. She said that he was sitting on the patio of their home, talking on the phone, ran him through, and that when she first called police, she said she had been in bed and did not know how her husband had been stabbed, and then later claimed he had been drunk and tried to bash her.
Okay.
I want to point out something here. If you've been in a violent situation for 19 years, living in a town where your husband is one of the richest and most respected men,
Mm-hmm.
are you necessarily going to admit what happened on the first bounce? If you've lived in fear for that long, people don't automatically fess up to what they've been through, what they've experienced, what they've endured when a police officer turns up on the doorstep and finds a corpse with a sword through it. It's hard to expect that level of veracity, honesty, transparency, and openness from traumatized people.
Yeah.
And yet this is what the prosecution was basically saying. Well, you didn't tell us the truth straight away. Now you're saying you were bashed.
Yeah.
So we don't necessarily believe you because you didn't disclose immediately.
Sure.
Let's contrast that for a minute with the way that prosecutions deal with victims of sexual abuse.
Mm-hmm.
Oh, it's taken you 15, 20 years to disclose? That's fine, we believe you. And that's how it should be.
Yes, of course.
Absolutely.
Of course.
Why are we not, in 2003, 2004, seeing the same empathy extended toward victims of domestic violence?
Mm.
And the simple answer is because black and white.
Yep.
We have a body with a sword through it. No sign of a fight. Therefore, it must be murder.
Yeah.
And we want the jurors to find that it's murder.
Mm-hmm.
Obviously, Ms. Savchik's counsel, also now a judge, Paul Cuthbertson, said that's not the case. He said it was par for the course that Mark Savchik would come home drunk and that Ms. Savchik was therefore afraid of him. He said that on the night he died, Mark Savchik woke Ms. Savchik up violently and menaced her with the sword. Quote, the deceased attacked her with the sword. She grabbed it, her hands over his hands, and stopped it from waving in her direction. She was frightened, being attacked, and she defended herself. In the course of that defense, the drunken and clumsy deceased was probably pierced by the sword.
Okay.
It's pretty muddy right now, isn't it?
And two very different stories so far.
How do you get from sitting propped up in a chair with a sword in your back to drunkenly fighting over a sword?
And somehow, non-intentionally, this sword being, plunged through someone in that sort of manner. Two very different circumstances and stories.
Well, there's only one way to solve this dispute, and that's calling evidence.
Okay.
And we've talked before that you don't have to prove yourself innocent. The prosecution has to prove you guilty beyond
Correct.
reasonable doubt.
Yeah.
Ms. Savchik actually took the witness stand.
Okay.
She gave evidence.
Is that a normal thing in a circumstance like this, that a defendant would take the stand?
How do you call it normal to Sean all the way back in 2003, 2004, who's just starting to get his head around this?
I'm going to say, with the hindsight of Sean's 18 years plus, looking back, would that be a normal thing if you were now knowing what you know?
With this seemingly impossible factual disparity, absolutely normal.
Okay,
because you don't
sure.
have a choice.
Sure.
You can't take the risk as a defendant that the jury's going to accept your lack of speech
Okay.
as evidence, especially when you've already been criticised for taking time to disclose
Okay.
violence.
So you need to step up there to be able to give your version for no other, I guess, reason except to give a version to the jury that they can consider.
Needs a funny word.
Okay.
Needs a really funny word, because if a prosecutor or a judge decides to express in court that someone needs to stand up and give their side of the story, you've deleted their right to silence.
Okay.
Because
Sure.
everyone has the right to not say
sure.
anything that's incriminating. So you can't get into need. Is it smart tactically? Absolutely.
Okay. That makes more sense.
Could it be the best thing you could possibly do to
Sure.
help yourself? Absolutely. But need, you got to watch words like that.
Yeah,
Because,
absolutely. That
otherwise,
makes sense.
Otherwise, you're saying, well, I don't believe her unless she gets up on the stand.
Yeah.
You have to prove to me, oh, nope, sorry.
Yeah.
You don't have to prove anything.
So, in your opinion, it's a very good, tactic to take at this stage to provide your version of the story to the jury.
And it's a good tactic that is born out of situational unfairness.
Yeah.
Because, again, you don't have to prove yourself innocent. Yet in a domestic violence space, we're instantly saying, well, unless she fronts up and says what she did, we're going to believe the guy who may or may not have been beating her for 19 years. The system's not geared for that at this point.
Yeah.
It doesn't have the subtlety. It doesn't have the mechanisms to recognize that right to silence might be out of trauma,
Sure.
out of fear, rather than just out of fear of getting caught.
Yeah.
It's all built on that black and white circumstance of, if you don't speak, you've got something to hide. Something to hide that is criminal, rather than something to hide that is traumatic, personal, embarrassing, humiliating. Let's put ourselves in Miss Savchik's shoes for a minute. If the most powerful man in your life has been humiliating you for 19 years and everything you say has been cast aside as useless, worthless, without any consequence, how do you have the faith that 12 people on a jury are actually going to believe you?
That's a tough ask. It really is, because as you said, if I've been acclimatized, if you like, or become accustomed to the fact, conditioned is the word, absolutely, that my version, my take, my opinion is worth nothing, and it's been cast aside, as you say, how on earth, in probably the most important circumstance in my life of proving not my innocence, but certainly giving my version of how this has occurred to a group of complete strangers in that sense, who are, by definition, judging me on what I've done, how can you have faith in yourself that, A, you can be trusted to yourself to do that, and your word is going to be taken and listened to in that sense as well?
And that's the choice that Miss Savchik had to face, and she chose to take the stand. Imagine that you're 19 years old. You meet the man of your dreams, you fall in love, you get married.
Mm-hmm.
He's got a really lucrative business. Everything's going great.
Sounds like a fairy tale so far.
Absolutely. You fall pregnant, you have your first child,
Mm-hmm.
and that's when everything goes wrong.
Right.
That's the story that Gwenda Savchik relayed to the jury as she stood in the witness box of the Supreme Court back in 2004. It was really hard to listen to. She was composed, but she was very quiet.
Mm-hmm.
The judge had to ask her, not unkindly, but regularly, to speak up.
Right.
Speak directly into the microphone so the ladies and gentlemen of the jury could hear them.
Okay.
She had a lot of trouble telling her story. This was a person who's used to being shut down.
I was
Shut
gonna,
off.
I was going to ask, when you said obviously very quiet and then having to be asked to speak up in that sense, do you think that's an effect of the years of, as you said, being shut down, being put in your place, probably not speaking out or speaking loudly because of that fear?
Back then, I didn't have the emotional maturity to know. Looking back, absolutely.
Right.
With the benefit of the hindsight and the experience that I have now, this was a traumatized human being.
Sure.
Trying to dig through the worst days of her life. And she had plenty to choose from. I mean,
Okay.
just before her 19th birthday,
Mhm.
she met Mark. From that point on to the age of 47,
Yeah, right.
her entire life had been defined by his treatment of her. She said, the early years were quite good, but he became jealous of the time I spent with the baby and he'd go out on weekends drinking. As things got difficult in the business, he drank more, he got more aggressive. It was verbally worse and physically worse.
Mm.
He started drinking in the shed every night and not coming in for tea. He seemed to pick on me worse when the children were away. He would call me stupid and make me look like a fool in front of the fruit packers, making me look like I didn't know what I was doing. She said that there was violence towards one of their children, and here's the one that really gets me and stuck with me all the way to this day. Mark Savchik complained about a family pet one day.
Okay.
Then the pet was never seen again.
Mm.
What does that tell you right there?
Well, there's an implication that Mark removed that said pet.
And we talk a lot about factors leading up to violence. You talk about, for example, children pulling the wings off flies and that kind of behaviour.
Escalation points, yeah.
And also, in the context of domestic violence, damage being done to pets
Yes.
is a big part of that as well. That sort of systematic terrorism that goes on. You could see all the factors building up. But in 2004, we didn't have the language for this.
Yeah.
We didn't understand this. Like right now, I look at this and go, my God, this is textbook.
Yeah.
Absolute textbook. But we didn't know that back
Yeah,
then.
absolutely.
This is people with rocks trying to start a fire.
Well, essentially, we are in the very, very base level premise of starting to define this textbook.
Absolutely. As Miss Savchik said, I would go to bed or just go out on the patio and have a smoke and try to keep away from Mark until he calmed down. I said to you that she didn't have a clear recollection of the moments leading up to the killing.
Yeah.
But she knew what had happened before those moments.
Okay.
She said she was woken up by Mark pouring beer on her head
Yeah, right.
and trying to strangle her.
Yeah.
Strangulation was something he hadn't done to her for a very long time. It had been all the hair pulling to try to hide the bruises.
Sure.
So when he strangled her that night, she honestly thought that she was going to die.
Okay.
But he stopped. Then came back a few minutes later with the sword and started waving it at her.
Yeah, right.
That's where her recollection stopped.
Okay.
This was incredibly powerful evidence.
Mm-hmm.
And again, like you say, we're at the beginning of writing this textbook. Imagine being the 12 ordinary members of the jury who are asked to now decide, is this murder or manslaughter?
Absolutely.
Like, what a task to be given.
Sure.
Won't surprise you to hear they deliberated for 9 hours.
Okay.
At the time, one of the longer jury deliberations I'd sat through.
Sure.
They came back and found her not guilty of murder,
Mm-hmm.
but guilty of manslaughter.
Okay.
Great. Absolutely. The jury has ruled that there is an element of self-defense here.
Yeah.
But let's go back to the Jack Hanley case. What kind of self-defense are we talking about here?
Mm-hmm.
Is it excessive? Is it expected?
Yeah.
Is this voluntary manslaughter? Is this accidental manslaughter? There's still a lot of questions that are flowing around this.
This is exactly the shades of grey I mentioned right at the start of this episode. Black and white is wonderful. We don't live in a black and white world. We live in multiple shades of varying grey. This being one.
Well, here's the bit where you get angry. Because the prosecution, faced with a loss.
Mhm.
They didn't get the murder conviction.
Right.
Decide to double down. Prosecutor Liesl Chapman says Ms. Savchik should be sentenced on the basis that she deliberately stabbed her husband from behind with the 1-meter sword as he spoke to friends on a mobile phone. Exactly the case she ran at trial.
Which was not agreed to by 12 people sitting in the jury box.
That's right, the jury all but rejected that.
Correct.
Now, Ms. Chapman's argument was, well, they probably didn't reject all of it, so she can still be sentenced on that basis.
I didn't realise that was the prosecutor's decision to make up her idea of the mind of the jurors.
Well, it's not, but it kind of also is. Because
Okay.
you have to interrogate the
Yeah.
jury verdict to
Okay.
determine what sort of sentence should be imposed.
Okay.
So everybody gets a go at, throwing the bones in a bowl of blood and boiling them up and seeing what entrails rise and deciding this is what the jury verdict means. The legal soothsaying, if you will.
Okay. That sounds very much Magic 8-Ball style. Shake it around and see what comes up.
And, keep shaking it until you get the answer that you want.
Yeah, that's the part that scares me.
So like I said, the prosecution's doubling down. Doesn't change a thing. Okay, it's manslaughter, fine. Then we say it's manslaughter deliberately with a samurai sword through the back.
Okay.
Because she was sick and tired of being mistreated.
Sure.
Paul Cuthbertson, in defence, comes back and says, look, there's no way that this can possibly be voluntary manslaughter and a deliberate act, and this is why. He said that there were blood spatters found on the hallway walls and injuries to his client sustained to her neck and her cheek.
Okay.
Now, what'd she say? He strangled me.
Yeah.
You can easily imagine injuries to the neck and cheek area and a
Sure.
violent struggle when you're lying on a bed and someone comes at you with two hands.
Yeah.
He said, Mark Savchik was probably not intending to kill her or use the sword to cause a devastating injury. His track record seems to be a history of violence that falls short of anything that requires medical intervention. The jury must have thought that, given the couple's history, her stabbing him was more than was reasonable as self-defense.
Right.
I said to you way back when,
Yeah.
you come at me with a fist and I attack you with a chair, and it's excessive self-defense.
Correct.
What Paul Cuthbertson's saying there is she had no way of knowing that he wasn't going to kill her that night.
Mm-hmm.
But all the evidence looked at in the cold light of day suggests that he never would have done that.
Yeah.
He would have strangled her until she passed out, or he would have waved the sword at her and upset her, but he wouldn't have actually killed her. Because she chose to go one step further and take lethal action, believing that her life was in danger, despite the evidence, therefore it has to be classed as excessive self-defense.
Okay.
There's that black and white you talk about.
Yeah.
That's a forensic pulling apart of a very passionate, frightening, traumatizing moment.
Look, it's incredibly, as I said, there's multiple shades of grey there, and again, from a court system, justice system, we are trying to put a black and white lens over this. Which one does it fall? Does it fall black? Does it fall white? It's got to be one or the other, because we can't live in this shade of grey, because we need the definitive, because that's what our court process and our justice system lives by.
That's right. In a science fiction sense, it's trying to make Mr. Spock decide what James Kirk did. Kirk was always the passionate one on Star Trek, devil may care attitude. Spock was the analytical one.
Correct.
Here we are in a post-Kirk moment, asking everyone to think like Spock
Yeah.
to determine what sort of penalty should be
Sure.
laid down. Fortunately, this was all before Justice Ted Mulligan, the
Okay.
late, great Justice Ted Mulligan,
Okay.
one of South Australia's best jurists,
Okay.
hands down. This man was beloved and respected for all the right reasons.
Sure.
Like everybody out there, go Google Justice Ted Mulligan, the things that he did for people in this state, for women, for victims of institutionalized sex abuse, for the Indigenous community. Just, he's a legend, an absolute legend, and deservedly so.
Okay. Well, you've given me a little bit of a glimmer of hope here.
Absolutely. And look, here comes that hope rewarded. He said in sentencing, "This is a most unusual case. I must say that I have not seen circumstances of the crime of manslaughter which have any similarities to this case. It is on that basis I must fix a just sentence."
Okay.
Note the wording there. Not necessarily a lawful sentence,
No.
but a just sentence. And he looked at Ms. Savchik and he said, "You are a well-respected pillar of your community. You enjoy the comfort and support of your family. Keeping you in the community is essential to your own rehabilitation and to the psychological well-being of the rest of your family. It seems to me there is a depth of understanding about you, this offence, and the reasons for it. I had the opportunity to observe you during the trial, and I have reached favourable conclusions about your character.
Okay.
The ultimate sentence? 3 years jail with a 12-month non-parole period, suspended on condition of a 3-year, $1,000 good behaviour bond.
So at this stage, Ms. Savchik is not required to serve any time in jail.
None whatsoever.
Right.
Unless she commits another offence,
Correct.
which Justice Mulligan said, I don't think that's going to happen. You're not a danger to anybody.
It's not like that's not her background or a history to be of that nature. She's law-abiding apart from this one act. So on the basis of that, yes, it's guilty. Here is a sentence. We're suspending that sentence, however.
Sort of Damocles hanging over your head.
Sure.
Don't do this again. Don't prove us wrong.
Correct.
Now, this is exactly the circumstance that a suspended sentence was built for.
Sure.
And Justice Mulligan just knew he was going to cop it in the neck from the public as a result of this lenient approach.
Okay.
He even said in sentencing, sadly, a suspended sentence is often totally misrepresented to the public. It has not and has never been a soft option, particularly not in a case like this. That's judicial wisdom coming to the fore.
Okay.
I know you're all going to be angry, so I'm going to get ahead of the game. This woman's going to be monitored for the next 3 years. She's going to have to report to correctional services. She's going to have to live an incredibly law-abiding life, not so much as a speeding fine.
Yeah.
Otherwise, she might end up back in front of me, and I'll have to determine whether or not to activate that 3-year sentence that's hanging over her head.
Yeah.
That was the absolute best outcome. And look, we got asked recently on the Ask Sean Anything episode, how many times do you see outcomes that are lawful and just?
Yeah.
The Gwenta Savchik case, absolutely just and lawful.
That does seem to be a pretty remarkable result there with the Gwenta Savchik, I guess, case in that sense. You mentioned there that, this was one that you felt was both just and lawful.
Absolutely.
It's certainly one that I guess until then probably, I won't say it was uncharted waters, but it sounds like 2003, as you said, we were just starting to write that textbook of how we look at and understand and start to try and, compartmentalize or just come to some sort of understanding of what leads up and creates this situation. So I guess for me, knowing that was the result of this case, how did this probably, I guess, two-part, how did this, I guess, shape you and your understanding, as you mentioned, as well as how did it start to shape the law and what we would see to come?
I respected Justice Ted Mulligan as much as any of the judges that I encountered in my early days. Like we said, 13 months in, I was a sponge, just trying to soak up as much knowledge about the courts as I possibly could and adapt to what I saw as best practice.
Yeah.
What fit my morality and my understanding and what furthered my morality and my understanding. This very much furthered it. I don't remember coming into the Savchik case with a particular bent, one way or the other, a decision, a view of the evidence. But by the end of that, I'd come away with a lot of empathy and a lot of understanding, especially watching it roll out that way with the conflicting versions and then Miss Savchik's own evidence being the deciding factor. It really reinforced that whole idea of every time you think you've heard every side of the story, listen for another.
Yeah.
That's what it did for me. On a public policy level, on a law level, it felt like it was one of those rare times that the public conversation and the legal conversation were walking side by side.
Okay.
As we're starting to understand intimate partner violence, gender violence, and also domestic violence, the law seems to be saying, okay, here's something we don't know how to handle. Ted Mulligan has cut through the static and charted a course for us, and there's nothing the law likes more than a precedent.
This is true.
If we can keep pointing back to the Savchik decision, we can keep saying this is how we grow the law and how we make ourselves ready for the next Gwenta Savchik that comes before us.
So you're saying, it'd be fair to say that Justice Mulligan's decision here truly set a different path in that sense and created that precedent you talk about?
Absolutely. That was the lodestone case for so many years. You would hear it referred back, not necessarily just in manslaughter cases, but in also cases where partners had fought back and done non-fatal injuries.
Sure.
Because there were plenty of them as well.
Yeah, of course.
So if someone, picks up a pair of scissors and slashes their abusive partner across the face when they're menacing them, things like that, you would hear Savchik name-checked during the sentencing process.
Okay. So how did this, I guess, how did this manifest? What would this I guess, create in terms of that precedent that we would see moving forward?
The best example I can give you of that came 4 years later.
Mm-hmm.
In 2008, Noreen Jessamine Wheatra was being choked, struck, and menaced by Ross Owen Callion. Now, they'd been partners for about 7 years at this point.
Okay.
And it was, to put it politely, an on-again, off-again relationship characterized by excessive drinking, excessive violence.
Okay.
One of those situations where, in a less understanding society, as we were in 2008, we would have looked and said, they're no good for each other. They just shouldn't be together.
Okay.
Unfortunately, it came to the point in 2008 where Callion actually was strangling Ms. Wheatra on the floor of the kitchen.
Okay, so it had escalated to the point of absolute violence and to a strangulation.
And look, escalated is a strong word because in the 3 years prior to this incident, police had been called to their home 10 times. And on one occasion, they even had to use capsicum spray to restrain Callion and get him off Miss Wheatra.
So when I say escalated, it sounds like it escalated long before this and had just simmered at that boiling point from then on.
That's right. What had actually happened was Callion had been kicked out.
Okay.
He'd been told not to come back. We're done after the capsicum spray incident. Don't want anything to do with you.
Okay.
Of course, he came crawling back. Please let me back. I love you. Let's fix this.
Mm-hmm.
Miss Wheatra said, all right, we'll give it one more go. It turned into that violence almost instantly. It was a matter of hours, perhaps days, before she's on the floor having the life choked out of her. In desperation, she's reaching around for anything to save her life. Tragically, the first thing she closes her hands on is a kitchen knife.
Okay.
Plunges the knife directly into Mr. Callion's heart.
Right.
Kills him pretty much instantly.
Mm-hmm.
Of course, police are called. She's arrested. She's charged with murder.
Yeah.
This is where things change, and this is where the Savchik decision starts to have an influence.
Okay.
Ms. Wheatra pleads guilty immediately to manslaughter.
Right. Okay.
And says that I'm pleading guilty on the basis of excessive manslaughter, excessive self-defense.
Okay. So just, I guess, to clarify that. So in Savchik's case, we pleaded not guilty, full stop. This time, we're looking at a guilty plea to, and they're saying excessive manslaughter
Self-defense.
or excessive self-defense by way of manslaughter in this case. So a difference right there of how we approach the situation.
Because Ms. Wheatra's lawyers knew.
Okay.
We can point back to Savchik and say, well, look, excessive self-defense equals a suspended sentence in cases of domestic violence.
So that was, as you said, use that precedent. So the defense lawyers in this case said, we can use that Savchik situation as the precedent as to your circumstance.
That's right.
Okay.
Greg Mead, SC, Ms. Wheatra's lawyer, said she would probably punish herself for life.
Okay.
Her grief-stricken reaction comprehends a range of emotions from sheer disbelief to remorse to anxiety that the kids will hate her to anger at Callion for leaving her and then back to unrestrained grief.
Yeah.
This woman cannot be punished by the system any more than she's already punishing herself.
Yeah.
Prosecution, thankfully, agreed. Accepted the plea straight away, accepted the basis for it.
So the prosecution as well comes to the play and recognises the plea she's made for the reason she's made it, and they accept this one.
Absolutely, because they're saying, you are recognising your situation vis-a-vis the law.
Mm-hmm.
We are recognising that the law has changed, that Savchik has set a new watermark.
Okay.
Let's not fight this.
Okay.
Let's not mess around. Let's just get this dealt with. Let's show some empathy. Let's show some understanding. Let's continue this conversation about evolving the law.
And for that clarity, because we make a guilty plea, there's no trial. Because guilty, we go straight to a sentence. Well, we look at the evidence and situation, and then we go to a sentencing phase.
That's right. Go straight to the sentencing phase.
Okay.
Submissions like what I just said, Mr. Mead said,
Absolutely.
are made in mitigation.
Sure.
And then we get to the sentencing. Justice Margaret Nyland said to Wheatra, while you admit you used excessive force, Callion's conduct substantially mitigates what you did.
Okay.
So mitigate, meaning makes it less severe.
Sure.
What you did was not justified, but explained away and counterbalanced, if you will,
Counterbalance is a good term, I think. Yeah.
by his actions. Yours, she said, is a rare and exceptional case which allows me to take a merciful approach to your crime. Very similar wording to what Justice Mulligan said in Savchik.
Yeah.
Callion was acting both physically and verbally in an aggressive manner. I'm satisfied that he grabbed you by the throat and pushed you into the kitchen in full view of 2 of your children.
Oh, goodness. Okay.
Horrible, horrible situation.
Yeah.
The end result, a 5-year jail term, suspended on condition of a 3-year bond.
Okay.
So for the next 3 years,
Yes.
Ms. Weecher would come back for sentencing if she committed any other form of crime.
Right.
But again, not a danger to the community.
Yeah.
Not someone that's going to run around and randomly stab people with a knife when she's angry.
Yeah.
This is someone who took the most extreme action possible in the most extreme circumstances imaginable.
Yeah. So I guess by virtue of that situation, we get from the first case, Savchik, to this case, the same outcome.
That's right. In that 4-year period, you're seeing that the precedent set by Savchik has held up against the first test, which is who's going to be the next person that finds themselves in these unfortunate circumstances.
And that was kind of what I was going to ask you about and trying to allude to, because if we look at the first case, we went through a trial process and we had some argument back and forth. And as we made the case, we were at the very start of trying to write the textbook of understanding how this circumstance plays out and all the components that go into that. We were kind of, for want of a better term, we were scratching on cave walls here trying to make diagrams around that. We put a precedent in place. Justice Mulligan says, I recognise the circumstances that led up to this. Here is your sentence. However, I'm suspending that because you're not a danger to the rest of the community. It's in this sort of vacuum isolated situation alone. As you said, we come fast forward 4 years onto that and we come up with this case in a similar circumstance with a similar set of situations and circumstances, I say, around it. We get to a point where this defendant says, actually, I'm pleading guilty because of that self-defense, and I recognise it was excessive self-defense, but there was a self-defense element to that. The prosecution accepts that because now we are that 4 years smarter. We've got that I guess, definition, defining element from Justice Mulligan around that to get to the same result without saying crass, the pomp and circumstance to get there.
This is what's referred to as good law.
Right.
A law is made or a precedent is set that means that the system works better down the track.
Sure.
That the next person isn't going to have to go through the same ordeal.
Okay.
Let me point you again to something that Justice Nyland said. Yours is a rare and exceptional case.
Yeah.
The fact that over the 18-year period we're talking about 5 cases.
Yeah.
5 cases that fit this definition of an intersection between self-defense and domestic violence. It means it is good law.
Yeah.
These are rare and exceptional circumstances, rare and exceptional cases. Nothing's changed.
You say nothing's changed, Sean, and we are going to investigate, as you said, those other cases around this. We've seen already a shift in quite a big way, if you like, from where we started in 2003. We got through to 2008 in this case. Coming up, we're going to cover a couple more cases in our next episode, which is really going to start to, I guess, pressure test some of this.
Yeah, you said, in a vacuum, these
Yeah.
are exceptional circumstances. Nothing lives in a vacuum.
Correct.
And no amount of good law can necessarily withstand what comes down the pipeline.
Absolutely. Our next case, essentially, do you want to give just the merest of hint, I guess, to where this next case that we're going to talk about goes?
There are cases that I've covered over my life that can be summed up very quickly in a sentence. This one, penis burning.
And with that, we're going to have to come back next week to unpack exactly what Sean meant by that statement, which I'm going to allow him just to sit on that with his voice. I won't repeat it, but you heard what he said. We're going to come back and look at what that case is and how that plays into that shifting landscape of what we understand, that intersection we talk about between domestic violence and self-defense. Until we get there, once again, we recognise these episodes particularly may be triggering, and so we want to remind you once again of the Domestic Violence Crisis Service on 1300 782 200, Domestic Violence Gateway Service on 1800 800 098, National Sexual Assault, Domestic and Family Violence Counselling Service on 1800-RESPECT. We mentioned it in our earlier episodes as well. The Zara Foundation at zarafoundation.org.au, as well as dvsafephone.org as well. We want to thank everyone for listening to us on the broadcast at 5AA or if you've heard the podcast on both iTunes and Spotify. If you could go rate, review, please get in contact with us as well on our social media at Just Lawful Podcast on Facebook and Instagram, at Just Lawful Pod on Twitter. You can, of course, follow Sean and all his work with the advertiser and Adelaide's True Crime on Facebook and Twitter at Sean Fuster. Until we pick up the next piece of this series, we want to remind you once again, enjoy our work, but don't become our work, and we'll speak to you on the next episode of Just Lawful.